Hi everyone, my name is Paul. Thank you for joining me in this video, part 4 of my series regarding my case against the City of Dearborn in front of Judge Eugene Hunt. In this video, I'm going to talk about discovery. Subchapter 2.3 of the Michigan Court Rules deals with discovery in civil procedure. If you are not familiar with discovery, it's a great idea to take a look at this subchapter. There are different types of discovery, including depositions, interrogatories, request for production of documents, and request for admissions. I was not interested in depositions, nor was I interested in request for admissions, so I won't discuss those here. However, interrogatories and request for production of documents did play a role in this case, so I will discuss those in some detail. Interrogatories are discussed in section 2.309 of the Michigan Court Rules, and requests for production of documents are discussed in section 2.310. Now these may be discussed in other sections, but I use these sections to start with. Now it's not possible for me to go over all details with regards to these, but I will touch on what I found confusing or important. With interrogatories, you ask written questions of the other party. They must answer each question separately and under oath. They must provide such information as is available to them or that they can obtain from, in this case, their employees or their agents. They can object to questions and must provide a reason for their objection in lieu of an answer. They cannot simply object without a reason. First of all, regarding my responses to the interrogatories, I did not try to guess at what the city was asking. If I honestly did not understand what their question meant because it was unclear, I did not guess. I simply stated that it was unclear. Take a look at their question here. You'll see that it asks about water repair issues. I was not familiar at all that they had issues with their water repairs. Therefore, that's what I wrote. Could they have meant something different? Perhaps. However, unlike depositions, you don't get a chance to follow up with a clarifying question right away. You have to get the question right the first time. This point also forces the writer to be clear and to base his questions on the facts. If you remember my last video where I discussed the pretrial statement where Mr. DeBiasi mentions or comments to the court that the second sinkhole occurred 2 months instead of 6 days after the first one, what would have happened if in his question he referenced the sinkhole that occurred 2 months later? Well, I would have done the exact same thing as I previously noted. I would have said that I am unaware of any sinkhole that occurred 2 months later. So what did William DeBiasi do? He made sure that he used the proper time frame in his questions. I'll try to show you here. There were many pleadings following discovery where Mr. DeBiasi indicated that the two sinkholes occurred 2 months apart, several months apart, sometime later. However, he knew early on that they occurred only 6 days later. How do we know that? We have proof right here in these questions. We also have proof in his responses to my questions. As indicated previously, these false claims misled the court and hurt my case. Back to the interrogatories, I also tried to be mindful of my questions when answering their questions. For example, I want you to compare these two questions, on top by me and bottom by them. You'll see that they are pretty similar in scope as to what they're asking. Here are our answers, basically both objecting to the same question. Mine, as you can see, is significantly more wordy, but we're both basically objecting for similar reasons. Yet Mr. DeBiasi's motion to compel, which is a motion that asked the court to force me to answer questions, said that I had to answer my question. At the hearing, had this come up, I would have informed the judge of the similarities of our questions and informed the judge that the city objected to my question, yet they expect me to answer theirs. I would ask the judge or inform the judge that the city should not be able to have it both ways. They can't object to my question and then insist that I answer theirs. For some reason, William DeBiasi seemed to be hesitant, for lack of a better word, to providing me with the expected testimony of his witnesses. As just shown, when I asked for what his witness's testimony will be, He objected and then pointed me to another answer which he provided earlier, which only provided the primary witnesses. No expected testimony was provided. Remember last video when I discussed the pretrial statement? One of the items requested by Judge Hunt was witnesses likely to be called at trial and their expected testimonies. In the city's response, they rewrote the request from the judge and then responded underneath. When William DeBiasi rewrote this question, he left out the "and their expected testimonies" and of course didn't provide this information. Therefore, when he only provided the witness names, it appeared that he had answered the question in full. Finally, I want to discuss what I did when the city did not respond to my interrogatories. First of all, I sent them a reminder. If you take a look at the Michigan Court rules, it indicates that the other party has 28 days to respond to interrogatories. It further indicates that you can file a motion to compel if there are no answers provided, but also indicates that you'll have to include in that motion that you reminded the party that they haven't responded. When I did not receive the city's responses to my interrogatories, even after I sent them a reminder, I filed a motion to compel. How long did it take for the city to send me the responses? 60 days. Yet even those responses were not adequate. I decided to keep the hearing date and to inform the court that the city did not provide proper answers to my questions. This was going to be my first time in court, and man, was I nervous. In the next video, I'll discuss what happened in court, other than, of course, a lot of hyperventilation and sweating. I hope you'll join me. Thank you.